We all know we have no voice, but we're expected to trust that we do. Here's the truth, though. In Saskatchewan, we do not have a voice. And our system is set up very differently from Alberta's. In Alberta, they have the power to trigger a referendum. We all know that. But what people may not realize is that in Saskatchewan, we don't actually have that same power. The only way to get a binding referendum is for the provincial government to instigate it. In Saskatchewan, we have the power to petition for a non-binding plebiscite. Unfortunately, the words non-binding mean that our government does not have to follow the results. They can completely ignore it. And that's why lately there's been a lot of talk about signing the intention to sign a petition. And that is fantastic. It's great to have people feeling empowered, but it's a little bit dangerous because those same people then don't realize that what they are doing can't actually produce the change that they're trying to make. In our system in Saskatchewan, local municipalities, they do have legislation in place to make them listen to referendums. So we can petition there, not at the provincial level. So, you know, this imbalance shows why we are starting to believe that one of our best avenues is to use the courts to help force a change in Saskatchewan. You know, we've seen this imbalance firsthand. We all know that the NDP has tried to get a bill through the legislature that would basically silence citizens' voices in our dissent and make it illegal to hold a referendum on independence in the province. Luckily, that didn't pass, but we know that it is pretty close to being able to. All it takes is a few MLAs not being there that day, and something like this could get through. Some groups have suggested that joining the Sask Party and forcing them to change from within is a solution. In my personal opinion, the time to do that was about 10 or 15 years ago, maybe even 20. I think that the structure of the party at this point is probably so ingrained that I don't think we would stand a chance. Doesn't hurt to try. It's always great to have more motivated people involved at that level, but I don't think we have the time, and I don't think that they would allow those changes to take place. And, you know, the real problem is actually the law itself in the first place. So we feel our only path forward is through the courts, and this, I'm not just going to be glancing at my notes at this point. I'm actually going to read this for you so that I don't get any of this wrong. Saskatchewan's laws governing referendums and plebiscites are outdated and obstructive. Legal action allows us to challenge these laws directly and demand they be modernized so citizens' voices are recognized and respected. A successful challenge can force the provincial government to create a framework where citizen initiatives matter, where outcomes cannot simply be ignored, and where accountability is real. The 1998 Supreme Court secession reference provides the foundation for this. That ruling made it clear that the people's voice is central to democracy, and a clear expression of citizens' will cannot be ignored. Citizens should have a legal right to have their collective voice recognized. Changing the law for referendums and plebiscites is not just about separation. That could be used in many other areas of our governance and our daily life. However, right now, our people just don't have the option. Even our chief electoral officer said in 2019 that Saskatchewan's legal framework for conducting a referendum or plebiscite urgently needs to be addressed and modernized. Until such updates are made, no meaningful preparations for holding a provincial referendum can be made. That wasn't said last week or last year, that was 6 years ago, and our provincial government has not taken any steps to correct those problems. They don't want to. They want status quo to remain the same. For this process to succeed, we need everybody, all the groups, all the like-minded people to work together. We propose signing affidavits expressing that the law needs to change in Saskatchewan to uphold the Supreme Court ruling, modernize petitions, and allow online signatures like the federal system, lower thresholds to an accessible limit. And you know, this is how we build a record. This is how we make the courts listen. And we need the courts to listen before we can actually get the signatures on a petition to start the ball rolling to independence. Saskatchewan life, you know, for all its challenges, still gives us lots of reasons to laugh. Most of you probably drove through the city to get here today. Some of those potholes are more like geographic features. I'm pretty sure that they can be seen from space. They probably show up on Google Maps. You know, and then there's curling, and we have the mash spiel coming up here pretty soon. And as I often mention, when Sean is doing his weekly mashup, curling and bondspieling are not the same thing, and I think probably everybody in this room knows that. But these are all the things, you know, traffic jams, getting up to take the kids to the rink at 6 o'clock in the morning. These are the things that bind us together, but that won't solve our problems. Canada was designed right from its very outset to keep the West subservient to the East, and we have to join together to try to do something about this. It's never going to get better without it. The thing that's going to suffer is our children's future, and we appreciate all of the help that the Alberta Prosperity Project has offered to give us, but they can give us guidance and send us off in the right direction, but it's something that we have to do for ourselves. So I hope that one thing that you all take away from this today is that the very first step that we have to take is making sure that those laws in Saskatchewan change so that we can force the government to listen to us when the time comes. Thank you. Sean didn't even have to kick me off the stage.